Hello and welcome to Legally Speaking with me, Tarun Nangia. As there is a saying which says that may you live in interesting times. Indeed, all of us are living in interesting times. None of us ever thought that people for up to more than 7 months wouldn't have ever ventured out of their houses. But as we see, the leading arguing counsels of India are there with me today on Legally Speaking, and they have been never as busy as they are appearing in so many cases from their homes. We have somebody who runs one of India's busiest litigation law firms. May I introduce my panel today on Legally Speaking? I have with me Dr. Abhishek Manu Singhvi. Frankly speaking, he needs no introduction, but I would like to give it. He's a third-time sitting Rajya Sabha Member of Parliament, senior advocate. He has served as the Additional Solicitor General of India. And there are so many nomenclatures that one can have for him. But I would like to thank him for making time today for my show. I have Mr. Rajiv Nayyar today on Legally Speaking for the first time. I would thank you so much for sparing your time today. As we all know that he's one of the busiest counsels representing top corporates of the country and so many multinational companies. And today we would have the benefit of listening to him as to how he has worked during in litigation during the time of Corona that we are all suffering or going through this phase. So, and we have with us Mr. Ryan Karanjawala, someone who runs one of India's top litigation law firms, who routinely makes so many, engages so many senior counsels to appear for a lot of cases that they take up. We will start from the introductory comments with Mr. Karanjawala. Sir, if I may ask you, what has been this litigation experience like during the Corona times of today?
Tarun, just by way of a small this thing, what you started off with a phrase called "May you live in interesting times" has actually over the years always been described as a Chinese curse. When the Chinese wanted to curse someone, they always said, "May you live in interesting times." And we are at this moment living in such times. So the question that is asked to me is, what is the immediate impact that we have felt of this pandemic on our practices? Now, there are two obvious and basic impacts which have been felt, which I'll deal with straight away. And then there's a third one which I myself have observed, but I'll allude to that a little later in the program if I think it's relevant. I don't remember, you were a little young, Tarun, but I don't know if Manu and Rajiv Nayyar will both recollect that when the first satellite phone was introduced into the world, it came by way of an advertisement. I still remember that advertisement. It was a full-page ad, came out in the paper. There was a photograph of the satellite phone, and on top of it were 3 words. It said, "Geography becomes history." Now that is what has happened to litigation and advocacy in the times of the pandemic. For example, let me give you an example. Manu will agree with me, Rajiv will agree with me, that one of India's greatest and busiest and most counsels was a man called Ashok Sen. Ashok Sen had a prodigious practice. We don't need to elaborate on it. And the other thing about him was that he was irrepressible. He would take matters in whichever number of high courts he could take matters in. And one story, the legend goes about him, is that on a particular day, he started early morning in the Shimla High Court, did a matter, took a private plane, reached Chandigarh before lunch, finished a matter in Chandigarh, reached Delhi before lunch, Delhi after lunch, and finished a matter in Delhi. And everyone said, "My God, he's appeared in 3 separate high courts in one day." Today, twice a week, Manu must be doing the same thing, and Rajiv himself must be doing exactly the same thing. So that's the first thing that this pandemic has done. It has sort of just made geography history. Today, sitting from where we are, we can handle matters in different parts of the country. Not so much my firm, but people as busy as Rajiv and Manu. And Manu will tell you his own experiences of how sitting in one place, he has been able to handle far more work than he earlier would have been able to handle. So the variety of your practice has, as a result of this pandemic, changed in the sense that you're not doing different kinds of cases, but you are appearing in many different kinds of forums which you would never ever have been able to reach. The second and somewhat obvious fallout also of this pandemic is that it's not just a pandemic which makes people sit at home. It's a pandemic which has caused a lockdown of economic activity. And any such lockdown of an economic activity necessarily means that the clients almost automatically ask you for a bit of a rebate. So to some extent, there has been that issue also, that the law firms, and I think perhaps even the councils, I don't know, they'll speak for themselves, have had to deal with that. Sometimes the clients find themselves in a harder position. They lean towards you and say, look, we've always been with you, do accommodate us on this occasion. And then, at least as a firm, we have always had the policy that we should always reward people who've been with us through the times. And we have been quite flexible about it. These are the two obvious impacts I have found in the handling of the pandemic. There are, of course, many other internal problems which a law firm faces, which I'll deal with later, about how you have to keep your offices open yet closed, how you have to ensure that people as far as possible work from home, because, if one person gets COVID, then the whole office has to shut down and things like that. So that, at least as a preliminary, this thing is what I would like to say.
Thank you so much, Mr. Karanjawala, for your initial comment. Now I go to Dr. Singhvi, and I have learned one thing from Dr. Singhvi in all these years. The volume of your voice will not increase the validity of your argument. In a sense, his voice never increases in the courts, but the arguments that he makes pass muster many times with the bench. How has this habit stood him instead in these times? Because I know, for whatever the reasons, nobody wants to be shouted at when one is listening to a video argument. So this is said in jest, but I would like him to comment on it and also give his introductory comment.
Thanks, Tarun, for a very generous introduction. Now, the other perspective from the point of view of the litigator, which two of us are, and the third one runs a firm of litigation, is clearly that on your specific narrow comment, arguments are more disciplined, they are more pointed, they are not necessarily briefer, but certainly more pointed and precise. Interruptions are less by the very nature of the process, and therefore it is a more harmonious process of arguments, clearly. Secondly, while broadly agreeing with Ryan, I think you have to see the flip side also. I think it would be wrong to suggest as if practices have increased generally and across the board during COVID. There are two aspects here. I would imagine that at all levels, practice in quantum terms would have decreased. Now, all levels means there is a very top, there is a below top, there is a middle, and there is a below middle, and there are other levels. Secondly, don't forget there are many Indias in one, in every sector, and the legal sector is no exception. So if you take up the above middle and the top levels, obviously if somebody is doing X number of cases, he is doing X minus Y, even at the very top. There is no doubt about it. However, he would be much better off than somebody at the bottom of the heap. And that is the many Indias in one syndrome, because there are difficulties in other parts of India. There is a contraction because the whole culture is based. I'm talking of the litigation culture. I'm not talking of corporate culture. I'm not talking of chamber practice. I'm not talking of office work or in-house work for that matter. The culture is one based on personal contact. It's not so much the litigation part only, but the coming of the client. And I'm talking across the board for lawyers generally. After all, we are the second most populous country in the world on lawyers. So I think we have to keep these two contradictory things in view. But along with that, I think the remedy is not physical courts. There is a kind of a knee-jerk reaction across the board that, look, you have many Indias in one, you have people suffering, and the suffering is genuine. Therefore, the answer and the remedy is physical hearing. I don't agree with that, because the answer is partly that you are not utilizing fully your capacity. The Supreme Court is doing well, but according to me, it is functioning probably at 50% of its capacity. VIDYO is a good program, but it is not half as good as WebEx, which Rajiv and I use in the High Court. For some reason, I don't know why we don't shift to WebEx in the Supreme Court. Video works well, except when there are batch matters, where it doesn't work as well. Now, these are practical problems, and you need to shore up the capacity. I don't agree with the notion that you must under force and pressure come back to physicals. The perception in the bar has been that people who are reasonably well off are holding back physical hearings. That may not be a correct perception, because when they did try to, on a sample basis, open physical hearings, the response was 0.0 some percent for physicals. The reason is we are not allowing the virtual to take full play. There is no reason why we had constitution benches, that is 5 judges being heard on virtual hearing. There is no reason why you can't have a full court functioning with various courts in virtual mode. I would go further. As things improve, there is also no reason why you cannot have the same case having one side doing virtual and one side doing physical. Let me tell you that somebody got your flyer or your advance intimation of this program and telephoned me. He said, I believe you are speaking on this. Do you know that I am doing matters in district courts? This is what he said to me on telephone, where I am doing virtually, the other side is doing physically. So a lot of good things have happened, and we need to shore up our capacity of virtual, not to say it is permanent, but whenever physical is possible, come back to physical, but virtual should become embedded in our system. It should not be a occasional trespass or a temporary aberration. And one last point before I end, you'll be interested to know that at least 2 matters, one involving me personally, where I had sued somebody and 4 out of 5 people settled. All the settlements are done on virtual. There is no problem. Identification, digital, I've done it myself. Digital signature, settlement recordal, mediation is done on virtual. All digital. Now this is a fantastic thing. And lastly, the same person who telephoned me told me, an old Chandigarh couple who had come frequently to Delhi. And as you know, and as Rajiv and I know in particular, cases get rolled over next day, next day, next day. They waited and waited in Supreme Court. They came back 3 times, old couple. Now they can sit in Chandigarh and join and see the hearing. That's not a small thing for the person who has ailment, who has resource constraint, who has difficulty, and you know the system in our courts. So I think what we need to do is improve the capacity, improve the functioning, but don't have this mad notion that virtual must end, it's an aberration, and physical must start.
That's some very important points made by Dr. Singh. Very important that Supreme Court is a place where clients from all over India have to come, however rich they are, however poor they are. In a sense, this is an enabler where people from Kerala, Tamil Nadu don't need to come for every hearing. That's a very important point made. I'll go across to Mr. Nair at this point of time. What will be your introductory comment for today's episode?
Thank you, Tarun, for having me on the show. And I want to start from where Abhishek left. And that's a very important aspect, that going forward, what is the role of physical versus virtual? Because as we know, the pandemic is nowhere near an end. So we are looking at least at 6 to 9 months more before there can be some semblance of normalcy. Now in Delhi High Court, for instance, we went completely virtual. And I must say that the Delhi High Court system actually is the one which is working the best, because right from item 1 till the last item, you are actually online in the court. So you are actually getting a feeling of being in a court, because you are seeing other matters being done in your presence. And then if you want, you can exit as soon as your matter ends. So it's virtually like being in a court, but not in a physical sense. And Abhishek is right. The Cisco WebEx system is working the best. And I must say that the Delhi High Court has evolved it very well. Now, it was a challenge because, you know, this system, they started with a few judges sitting on some days. Then they expanded it. And finally, the entire court is online according to the roster. And let me just share with you, this is the only court where this system is being practiced. So every judge has his own roster. Of course, he has a lesser number of cases, but he has his own roster as is assigned to him, even if he was sitting physically. For instance, in Bombay, in Madras, etc., few judges are sitting only on a limited basis, on a day-to-day basis. Now, I myself have written 2 letters to the Chief Justice of Delhi High Court, and they have been carried on bar and bench, etc. And I have actually said that please don't open the courts physically, because you are actually going to open the courts and find that lawyers are going to be affected with COVID, and you'll have to shut the courts back again. So of virtual courts vis-a-vis physical courts, because actually everything is being done very smoothly. Abhishek is right, the numbers are down. But numbers are down not because they are virtual and not physical. Numbers are also down because there's less appetite for litigation. I am noticing that there's less appetite for litigation. People like to settle. Even huge multinationals and other corporates, etc., are going into litigation in a little reserved manner. I mean, they are not as if rushing into litigation the next day. So that's why the impact is being felt by the younger lawyers, because the litigation is not across the board. It's in a very restricted fashion. It's there, but it's a restricted fashion. And if it's in a restricted fashion, then people like Abhishek corner it the most. So, it speculates it less. And by the time it comes to lesser mortals like us, we have a few trickle of
law of stopper doesn't apply, right?
So that's how it is. But we must respect virtual courts. We must expand it, and we must give it teeth. Let's not react to this bar associations espousing causes of lawyers, because they are not espousing causes of lawyers, they are espousing their own political aspirations. And if you take not only me, if you take a sample across, 98% of the lawyers don't want physical hearing, at least in Delhi High Court.
That's two important points made by Mr. Nair. But one very important point he made, that how the whole community is envious of Dr. Singhvi, and I can vouch for it. He's being discussed.
You see, he's the last person who should be allowed to say all this.
Let me just say this.
Restrictive Trade Practices Act available and applicable in the High Court of Delhi, it is applicable to people like him.
Let me just say this. People are envious of both Dr. Singhvi and Rajiv, but they deserve every inch of the success that they get.
Yes.
So, I mean, it's well worked for, and they certainly deserve it. And I can say this because I'm on the other side of the coin. We're the ones who go to them, we're the ones who brief them.
But it's interesting addition to that, Tarun. It's very ironic. Just today, on my WhatsApp, the whole report has not come. The parliamentary committee with a title very similar to your program, obviously unknown to each other, virtual courts, or the concept of virtual courts, a parliamentary report has come. I happened to chair this parliamentary committee report earlier. I happened to chair this parliamentary committee earlier, Parliamentary Committee on Law and Justice. And it's very interesting that they've come down heavily in favor of virtual courts. And they have said that this should be the new norm even when normal times return. Of course, not at the cost of replacement, but at the cost of a parallel system, giving people the option. And remember one thing, Tarun, that, look at also the saving in many ways in terms of your own health, pollution, driving. I mean, these are things we take for granted.
Time.
For me and for a lot of us, that 9:45 time period is the worst. It's the burst tension, whether you're doing whatever you're doing. If you're called by the President of India, you must get in the car and drive. If you're living far away, if you're nearer the court, then 10 o'clock. Now, today, the luxury of going down and doing it at 10:15 and starting immediately when you get your virtual contact. The pollution, the petrol, the driving, and also I think the fact that judges have only to learn to be a little adaptable. They are already very accommodative, but a little impatience has to be less. Passos has to be accommodative. I'm not sure we can all do more cases, by the way. We can do more cases in multiple cities. That is certainly true. But I don't agree that we can do quantitatively more cases. There is an equalizer applying in COVID. I think it comes down because, virtual hearing has its limitations. But I think if you are able to, A, increase the system of VIDY over other systems which are not as good as WebEx, and B, the judges are little accommodative, I think there is no problem. And for that one other point, for that very small class of people who are genuinely disadvantaged, the elderly, the remote village, the tehsil court, where people don't have access to the platform, or indeed in Delhi, the people who are economically disadvantaged, I suggested an article, in fact, it was published in The Guardian, which is your sister concern, where I said that there is no reason why the Supreme Court should not have one or two big halls. So somebody who is really, need of it, I don't think there are many, it's exaggerated number. He comes there and in the hall there are 7, 8, 10 platforms from where he can do virtual, assisted by people. This can happen in tehsil courts and district courts also, and this should be reserved for the genuinely disadvantaged, either by age, ailment, technology, challenge, or resources.
Just to add here, insofar as in the Delhi High Court is concerned, there are 2 courtrooms where if you don't have access in your own house, you can come there and get connected. That's one. Secondly, on this parliamentary panel report, which Abhishek said is very interesting, because certain classes of cases have been suggested to be on virtual indefinitely. Like for instance, traffic cases, check bouncing cases, and those kind of cases. So it's a healthy development because, you know, for instance, you find that there have been successive amendments to the Negotiable Instruments Act, but a man who's a holder of a dishonor check has to wait for years because there are 6 months, 8 months kind of dates which are being done because courts are clogged. And thirdly, Abhishek has rightly said that this can never be the substitute, but we may perhaps marry the two into make a system which may become perfect in the near future.
But one thing is
a hybrid.
One thing is for sure, Mr. Nayyar.
A hybrid system.
Mr. Nayyar is happy with the way Delhi High Court has been performing on the digital courts front as a whole.
Yes, yes, absolutely. And I must say that all the judges, because I have actually suggested to the Chief Justice, now that we must move to phase 2. So phase 1 was urgent matters, and we have perfected the system well. But we must now have phase 2, that you must get the older cases. But you see, Tarun, what is happening now? All the cases which were originally, say, for instance, listed on 8th March, they are automatically adjourned to some date in April. So, you know, those cases are not being taken up. So urgent matters are being mentioned and taken up. So I have now suggested, and I think it's time forward, that actually those cases which stand adjourned to a later date should actually be taken. So a judge may have 20, 30, 40 cases. He may be able to do only 15 or 20, but he may have a rolling list. But at least the litigant and the lawyers who are clamoring for physical hearings, they'll get a sense that the entire court is actually performing.
Okay. Thanks for this input in a sense.
I agree with...
Yeah.
I agree with both Manu and Rajiv. In fact, I must say, speaking for myself, and I remember my initial conversations with Rajiv on this, I was a bit of a slow convert to the system of virtual hearing because I remember right in the beginning of the pandemic, Cyril Shroff of Cyril Amarchand Mangaldas had sort of on Zoom got a group of us lawyers. We're all part of a society of Indian law firms. So a whole lot of us had come on board. There was Cyril, there was Zia, there was Ajay Bhel, there was Rajiv Luthra, there was Rohit Kochar, there was myself, there was Mahesh Agarwal, Igrave of Khaitan and Company was to come, and there was many, many others. You know, and everyone was discussing, and Cyril had in fact mooted this whole thing of urging the courts to go towards a virtual hearing. And I was quite reluctant at that time. And so was Mahesh, because we were the main litigating firms, and we were a little apprehensive as to how it would suit the system. But as the system has worked more and more, we find, and especially with the suggestions that Rajiv has made for the High Court, we find that now things are working better and better. It is true that, and frankly, to be honest with you, there is no answer to that in the pandemic, because frankly, it's as the head of a firm, it's very difficult for me to insist, or even it would be in a sense wrong of me to suggest, because I myself am I have a few comorbidities and I am at a particular age. So I myself haven't stepped out of the house. It's very difficult for a person who himself is imposed a lockdown on himself to insist, no, but all of you guys line up. You know, it's not the kind of culture you want to inculcate. So what's happened with, we find that it's been working well for us. We find that, yes, obviously there are fewer matters. So there is less work than we normally would have done. But as it, with every passing month, I find work increasing and more and more matters being dealt with, more and more. The district courts, I think, have also opened up a bit, and so on and so forth. So as time goes on, there will, in any case, this pandemic can't last forever. It will end in about 6 months, objectively speaking, on an outer limit basis. Within 6 months, we hope to have a certain sense of normalcy. Now, even in that sense of normalcy, to take further what Manu said, I feel especially a court like the Supreme Court should function in a hybrid way. Part of the reason is that the Supreme Court is a court of many different geographies. Cases to the Supreme Court come from every different state in the country. Now, one way to deal with it would be that while you go back to the system of normal hearing, you can, on a particular designated date, say one day every 2 weeks, have all the courts sitting on a virtual basis. And on that particular day, if the Chief Justice so directs, he can direct the registry to ensure that people coming from the cases coming from a particular state find their way to a judge from that state. The advantage of that is that then the advocates who are practicing back in, say, Karnataka or Kerala, who come before the judge, find at least a familiar face they can see, and that particular judge also knows them. So he knows how good, how bad they are, and accordingly handles the matters, you see. So that's one way to look at it. The other way you could have is that a designated 1 or 2 courts of the Supreme Court always functions on a virtual basis. And people who want to come virtually are automatically relegated to that particular courtroom and their case comes up in a normal roster fashion. There are many ways, I think. One thing that the pandemic has done is it has showed us that there is a side to a virtual hearing which should not be abandoned merely because physical hearings are now again possible. And I fully agree with Manu on that. Also, as Manu said, there may be a time when you have a situation where you have in the same matter itself both a physical and a virtual hearing. One side opts to come from Karnataka, the Karnataka lawyer chooses to argue, and he comes and says, I will argue virtually. I'll listen in to what the other side is saying, and then I will deal with it. And that's also a possibility. There are many, many possibilities that are available, and I do feel that the courts will certainly have to, I agree with both of them, that the courts will, certainly the Supreme Court will have to do a lot in terms of upgrading and ramping up its web capacity and its, Bolo Mano?
No. No.
Yeah, ramping up its web capacity to an extent that it makes everything much more easy and much more comfortable. And Rajiv is right that we've been very fortunate that we live in a city in which the High Court, in terms of ability to handle matters, is the premier High Court of the country on this aspect. Because I speak to people, I was speaking to Darai Ambata the other day in the Bombay High Court, and I was speaking to some other people, and all of them find that compared to Delhi, the other High Courts are nowhere near functioning as well as the Delhi High Court is.
That's a fair point.
So this is something we have to look at.
Just on a lighter note, we are now, at least some of us, are now operating, like instead of running from court to court, we are actually operating from video screen to video screen. So you have a laptop, you have an iPad, so you can do 2 or 3 matters simultaneously, which it was not feasible to do so. But I just want to also add that Ryan gave the example of Ashok Sen, that he was able to do 2 or 3 courts in a day. What he actually forgot to add was that when Ashok Sen appeared in Delhi High Court, he suddenly, during the course of his arguments, feigned sickness and told the judge that I am sorry, I won't be able to carry on any further, and took an adjournment and then flew to Srinagar to do an income tax rate case. But here we are doing it more authentic version. We are doing from a video to video.
That's an interesting
point.
I would like to end the show on this point. Part 1, we are almost out of time. We can take this in part 2. Dr. Singhvi has to say something. So we will include that in part 2. But I would like to thank each one of you, Dr. Singhvi, Mr. Nair, Mr. Karanjawala, for sparing your time for our episode on litigation in times of Corona on Degree Speaking. We will continue our conversation in the part 2, where we will talk of the flip side, in a sense that what all issues is it occurring in litigation. We will also pay attention to that. Thank you so much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.